All right, just before we begin, testing. Is everything okay on the Zoom there? We are unmuted, right? 没有灭音了, right? Okay? Okay, so that's okay, and everybody here can hear me okay. Yeah? Okay, good. So welcome everybody to this seminar in the STL, Peking University School of Transnational Law, 北京大学国际法学院's Law and Humanities Seminar Series. And I'd like to welcome all of you who are here in person and also audience members joining on Zoom. We're very privileged today to have as our guest speaker Professor Dmitry Poldnikov of MGIMO University and also the Higher School of Economics in Moscow. And Professor Poldnikov's research interests and focus are in legal history, comparative law, and legal theory. He's published widely in these areas. The most recent contribution is a very important book, a 2-volume book, I believe, on legal history, comparative legal history, and comparative legal traditions. And he's no stranger to China. He's previously taught at China University of Politics and Law. And he's also served as a visiting scholar researcher at the Max Planck Institute in Germany, as well as Harvard Law School in the United States. And Professor Poldnikov today will speak to us on the topic of comparison of the world's major legal traditions on the basis of the role of law. He will speak for approximately 40 minutes, after which we will open the floor for questions. I would like to now give the floor to Professor Poldnikov.
Hello, everyone. Thank you, Professor Norman Ho, for this generous presentation. I'm happy to see you here at the classroom and online. My purpose here today is quite simple and complicated at the same time. I need to introduce you to the course on that I teach during half a year, which covers world's legal history. And I decided to build this presentation on the methodological, from the methodological point of view. So you see the title, and this is the outline of the presentation. First of all, speaking about the challenges that any scholar would face as he or she introduces this topic to his students. Then investigating this concept of path dependence and how it can be explained through legal traditions. Then somewhat analyzing this concept, showing Western roots and alternatives to this concept. And then going back to the essence of the course and seeing the explanations to the legal diversity of the world and coming to some conclusions. So without much ado, the introduction. First thing first, I suppose jurisprudence could be regarded as a great tool for communication between different civilizations, which suits much better contemporary world, better than religion, philosophy, or even economics, because every society strives for justice, and if we talk about this justice from different perspectives, we allow ourselves for better understanding. Second, I already, as Professor Ho mentioned, made a presentation at his seminar at the STL school, and if you are interested in the research that I do, feel free to watch it online. I suppose it is still available. So I will not repeat myself and address the main issue as to how to understand and explain path dependence in the law and how the concept of legal tradition can be of any value here. In explaining you my idea, I build on the previous research, which is available in English as well as in Russian, but I suppose English is more widely read these days. And there will be more references in the end of the presentation. So the first thing that any legal scholar faces and needs to explain to his students is how to look at the world's variety today, different legal systems which exist despite the obvious trends towards globalization and interaction between the legal systems. And the best concept the academics have to these days is the idea of some path dependency, which can and should be explained through the roots legal systems of today have in their past. And this path dependency can be discovered in all the domains relevant for the legal profession, that is in lawmaking, in legal techniques, and the methods of interpretation that academics or practicing lawyers use. And of course, in law enforcement, when professionals face the challenge of gap filling and adjudication, sometimes beyond the law, against the law in force. So in the literature that you usually read, in the textbooks that are available in English, the key concept here is legal tradition. And it seems that this concept is quite understandable. Legal tradition is some information and the process of handing down this information. But beyond this point, the consensus on this very concept, the central concept, is lacking. And there are at least three different approaches as to how to understand this concept. First of all, most scholars would subscribe to the idea that tradition is a kind of evolving a set of legal institutions. And in this sense, legal tradition is just the history of legal institutions. The second concept would be to regard legal tradition as the synonym of legal culture, which expands the scope of your research intention to a set of attitudes about law that needs to be taken into account when you try to understand the legal system. And yet there is a third understanding of legal tradition as a sense of continuity between past and present, and with somewhat religious understanding of our ancestors inspiring us moving beyond the present line to the future on the basis of the past. So these concepts of understanding legal tradition are portrayed now in several publications. They are popularized in English by American authors that I present on this slide. First of all, you can find a very recent publication of John Head, Professor Head, Great Legal Traditions, from operational perspective, published in 2011. He presents those legal traditions as the history of legal institutes. Then there is the second line of thought presented by John Merriman, Professor Merriman, who advocated the idea of legal cultures as legal traditions, and his textbook is continuing to be published even as he passed away. And finally, the third, or so-called messianic concept of legal tradition belongs to Professor Berman, Harold J. Berman, who famously authored the textbook of Law and Revolution. Well, the first volume was published in 1983. He focused on the origins of the Western legal tradition, and in that sense, he understood legal tradition as mostly Western legal tradition. And it brings us to the very point of this first half of my presentation, that is that legal tradition is a biased concept. That is, it depends on several premises typical for Western legal scholarship. This is not to say that if we discover this, we need to abandon it altogether. That is to say that we need to be aware of these shortcomings if we are to use it unbiased without putting an emphasis on the Western and making it as a criterion to evaluate Eastern and other non-Western legal traditions. So what do I mean by a biased concept? What are those biases? Well, first of all, those who crafted this concept, and these are not just the American scholars, of course, but also other European scholars, German historians, French historians, Italian, and so on. They built on Western perception of history as an evolution through the dialogue of the old and the new. It is not to say that other civilizations, non-Western civilizations, have alternative ways of thinking about the course of history. It could be perceived as a cycle rather than the arrow of time, or perhaps other concepts. Second bias. This concept of legal tradition is based on an attempt to single out the essential features of a legal tradition. And it belongs to the long European scholastic or Aristotelian way of analyzing concepts by believing that those concepts have their essence, something unchangeable, something that you distill, pinpoint with the criteria, the features, and use it as an unchangeable thing. As opposed to a contemporary view in postmodern philosophy that all concepts are constructed for a particular purpose, and in this sense they are changeable. So the second bias, right? The third bias, this concept presumes the law as an autonomous system of legal rules. That is, that law is somehow singled out from the religion, ethics, and other normative disciplines, which is typical for Western countries starting from the Roman period, Roman history, who juxtaposed use, that is law, to fuss, some religious concepts, and also to ethics, and passed on this knowledge through the basic text on Roman law, the Code of Justinian. But in other civilizations, in Muslim, in Hindu, in Chinese civilization, this separation of law and other normative systems might be not around, not that straightforward, and they build on the interaction between them. So, and yet another bias. The concept of legal tradition serves the purpose of classifying national legal systems, and explaining their origins. If you look at the history, even of European usage of this word, it used to be limited to the technicalities of passing on ownership. Traditio in Latin means that you pass on a thing and its title and nothing more for lawyers. But by the 19th century, the concept of a tradition was expanded to other spheres of knowledge, and ultimately it began to imply culture, even legal culture, that underpinned the nation state and its legal system. That kind of purpose pushed scholars to some anachronistic view of legal tradition from the point of contemporary nation building. It was not the purpose of those who were making this tradition in the past, in the medieval times. And finally, legal traditions are rooted in Roman and European history, which makes it not so much the neutral concept, but rather the measure stick for evaluating other legal systems and other legal traditions.
Professor Poldnikov, the microphone.
All right. Going to the next slide. If we are aware of those biases, then what are the consequences? And to paraphrase the idea of American specialist in the Middle East, Edward Said, we can talk about the so-called legal Orientalism. That is the perception of other legal cultures and their traditions as strange, bizarre, not normal, in other words, exotic, in other words. Law can be viewed as a structure of the political imagination, a distinctive manner of imagining the real, which can be used to subjugate the colonized people via colonial laws and court system. That is, to some extent, this concept of legal tradition was used to advocate the superiority of the Western legal traditions, the civil law and common law, over the perception of law in the countries colonized by the Western powers. And this legal Orientalism implies some mechanisms of asserting this Western superiority in the 19th century and in the early 20th century as well. What is this mechanism? So first of all, the colonizers branded indigenous people as lawless, living with wild customs. They created a system of colonial courts and a body of colonial law and judicial practice that eliminated local customs as wild and uncivilized. So typically, the scope of local customs was limited to family and inheritance matters, but for other relations, colonial law, normal law was introduced. So this is to say that the concept of a legal tradition is not a biased concept. It's not just a harmless thing. It can be politicized. It can be used as a tool to ensure one's supremacy. And this is not just a thing of the past. I am well aware that at this school one has to think in contemporary terms. So the lasting legacy of this legal Orientalism are some publications that still debate the thing of indigenous legal traditions slowing down the development of other civilizations that became colonies or semi-colonies of the Western powers. I'll just give you some examples on the slide. Well, discussing this topic in terms of West Asia, East Asia, and of course China, East Asia. To economize on time, won't stop on this. Should you have any questions, we'll be able to discuss it in the Q&A session. All right. So if this Western concept is biased and somewhat harmful to the perception of one's own history, reconstructed by the Europeans for the locals, by the way, can it be replaced? Are there any alternatives to the concept of this legal tradition, Western legal tradition? To the best of my knowledge, I was not able to, there were no pre-modern Asian concepts comparable to legal traditions other than the concept of one's own legal tradition. That is, as in many ancient languages, when you speak about your people, you use the word "we the people," while there is no word for describing other people, otherness. So much for legal tradition and your own law. You use the special word to mark it, like Sharia in Muslim law, or Hadith for tradition, for handling down information about the deeds of the Prophet. But you don't use the same vocabulary to describe Christian or Jewish law. Because your own tradition, let's say Muslim legal tradition, is incommensurable with other legal traditions. And also that was the way of asserting the superiority of your own legal tradition over the others. And there can be examples from East Asia and South Asia, but again, I don't stop here in order to be able to show you the whole of my presentation. All right, so the benefits of using the broad concept of legal tradition is to be able to describe different traditions and to compare them with one another, although with some biases. So what would be the alternative to the biased concept of legal tradition? I must admit that Western scholars also think in terms of decolonizing the language of legal history and comparative law. And one of the best efforts and most widely recognized is the textbook on comparative law by the Canadian professor Patrick H. Glenn, Legal Traditions of the World, Sustainable Diversity. First of all, he highlights the biases of the concept of the legal tradition in other textbooks and academic publications. And he suggests to replace these concepts with another more flexible idea of a legal tradition as a loose conglomeration of data organized around a basic theme or themes. So any kind of information about normativity can count as a legal tradition, and you cannot use it either as an essentialist concept. Legal traditions are constructed for the purpose of organizing the societies, nor you can use the Western legal tradition as the measure stick to assess, evaluate, and criticize, and ultimately replace non-Western legal traditions. His textbook was quite successful to kindle a wide debate in the English-speaking world, at least. But at the same time, I suppose it is not an easy reading, even for academics. And as I struggle to explain the legal diversity to my students, my guess would be to use this concept as an analytical tool to single out the major elements of a legal tradition. First of all, students must be introduced with the social setting and the actors, those who wield this tradition, those who investigate it, interpret this. Because if there are no tradition guardians, there will be no tradition. Otherwise, you would fall into the bias of positivism that the legal texts regulate social relations on their own. Now, if there are no judges educated in common law, there would be no common law, as the example of the colonized Egypt showed us. And on the contrary, the British India showed the significance of the judges thinking in terms of common law. Right, the second element is the so-called essential elements of the paradigm of law, which introduces the framework that embraces the sources of law, legal mentality, and ideology, ways of interpretation and application of legal rules that are used as the infrastructure to integrate and maintain a cohesion and coherency of particular doctrines and rules. In other words, specific legal rules and institutions are not just well, cherries upon the pie. They are part of a system, and they should be understood within this system, the context of this system. If you take it out and transplant in some other legal system or legal tradition, it doesn't mean that they will be understood exactly in the way as in the country of origin. So, and this is what I try to explain in the textbook that I managed to publish late last year. It is yet in Russian, but who knows? Perhaps if there is interest to reading this textbook, it will be translated in a shorter version. The point is to use the concept of a legal tradition from the functional perspective. That is, you perceive the impact of the legal ideas, legal norms, legal rules on the actual behavior of the people, rather than you try to find the essence of the legal tradition as the scholars used to think in the 19th and 20th century. And best of all, you can use this infrastructure as the plan to outline each legal tradition throughout the course, starting from the ancient times until fairly recent decades. So the second tool that can be used from the comparative law in order to explain legal history is the functional typology. The functional typology of legal traditions that can help us to start sorting out the diversity of legal traditions and legal systems. It is dazzling, of course, for a student to look at least the major legal traditions without some guiding light. This guiding light can be the role of law in the society. That is the perception that the society has towards the law that it uses. And according to this criterion, one can speak about law as a fair means to resolve conflicts. Let's say in the Roman Republic, they understood law in that way, and the British medieval judges understood it in that way. Also, you can perceive law as a path of correct or righteous behavior if you add some ethical emphasis to it or religious emphasis to it. So Sharia law or medieval Roman canon law in Europe or Indian Dharma Shastras were of that kind of law. And the third type of legal tradition would to assert law as the element of the rule, right? In this sense, one can speak about the rule by law, the social engineering, ordering, and the historical examples would be the Imperial Chinese, Imperial Russian law, and to some extent even Ottoman law. Another disclaimer, why do we talk about typology? Those are the types or the ideal types that famous German sociologist Max Weber used in the late 19th century in the sense of the starting point of the research. The point of using the ideal types is to compare the actual law with this ideal concept to prove how it is wrong, or to see how the actual law changes over time by comparing this with the ideal image. So for this reason, these ideal types should be introduced in the very beginning of the education to this course rather than in the end. The end would be the answer as to how the actual law of Rome, how the actual law of the Middle East diverges from this ideal type and why. So this is again the study tool, the analytical tool, which brings us to another perception of the rule of law, or the role of law. So typically, if you read about the rule of law in comparative law, well, it's just a good opportunity to crack a joke and to make a pause in this complicated presentation. What this typology can give us for a particular topic. So the rule of law is usually understood as an ideology born in the common law legal system in England and developed through the imperial history in Britain and passed on through the legacy of the British Empire. However, there is an alternative way of thinking about the rule of law as the social norm that gives the answer as to why people follow this law, why do they recognize it as a legitimate instrument to regulate their relationships without much pressure on them. That idea, again, is based upon the publications of those who study law and economics and perceive the law functionally, from the functional perspective. And it can explain why some societies start with following the law was created in their state, as in the Roman Republic, and then stop recognizing its legitimacy, as in the late Roman Roman Empire, when subjects try to avoid the legal domain as far as they can. And on the other hand, one can deconstruct the perception of the medieval Middle East empires as lawless if one discovers that in the Ottoman Empire, or at least in the central part of this empire, people followed the Sharia law without any compulsion. They trusted to the legal institutions, the courts there. They went to Qadi justice rather than they perceived it as arbitrary justice, as Max Weber claimed, by the way. All right. And now to the main discoveries. The rule of law as a social norm can be regarded, the basic idea is that as soon as you choose the methodology and you describe the historical facts, you need to think about the explanations. What stands behind those chains of events? At the moment, the best guess that me and another author to the article that I cited in the beginning, we try to explain the phenomenon of the essential role of law through the combination of the three key factors. First of all, it is the political competition of the social groups on the basis of the law of that society. Second, it is the professional community of someone we can call jurists or lawyers who develop and apply law independently of the administration, and they value this law. And thirdly, It is the law which is suitable for finding a compromise due to its internal merits, which helps all members of the society to accept the legal rules as legitimate, trustworthy, and follow those rules, actually. That kind of triangle can be found in the times of the Roman Republic. It can be found in English common law throughout most of its history, starting from the 14th, 15th century at least. It can be found in other societies that claim the state of justice, as in European history. And I suppose this triangle of factors is introduced in all other modern societies that claim to be ruled by the law rather than a man. Right? Contemporary China, Chinese Republic, can also its interaction can also be explained on the basis of those rules. All right. Then the main question for a historian is to ask what can happen to this triangle if the society or some groups of the society stop following the law. How can it be crushed, and why is it crushed? And the best guess today is that this triangle is destroyed when the political competition is won by the group which does not value the law. They work as an anti-system. They undermine the positive vision of law, and they do not try to replace with another ideal law. Rather than they are self-seeking, and it starts the chain of events that brings to the destruction of the prominent role of law in the society. There are some historical examples starting from the crumble of the Roman state, from the Republic to the Empire, from the early Empire to the late Roman Empire. And there are some examples, of course, from different parts of the world, including Russian history. So to conclude, I suppose this is about time. One should pay attention, even if you study comparative law, you need to pay attention to legal traditions, because otherwise it is difficult to explain the sustainable legal diversity of the world despite all the interactions of the lawyers. This concept might entail some legal Orientalism if you follow the description, the narrative uncritically. However, the concept of legal tradition can be revised and reused if you perceive it as an analytical concept in order to understand the law from the functional perspective and to focus on the role of law in the society. And finally, if you follow that line of reasoning, it entails an alternative narrative of the rule of law in a society as a social norm, which gives a more meaningful and comprehensible perception as to the sustainable development of the societies, even before the advent of the age of colonialism and globalization. Should you be interested in more reading on this topic, it is on this slide. There are some publications in English, of course. I think there are more in other languages, but as soon as we use this lingua franca, the good starting point is English, of course. And with this, I thank you for your attention, and we'll be happy to answer your questions. Thank you.